They've lost interest. As a result. Because I'd almost finished on Article 9, there are three matters that arose this morning I need to come back to. The first was the question of contractual liability, on which my Lord the President and my Lord Clerk asked questions. My answer was inadequate. There is a statute that addresses this matter. It's dealt with in the Joint Committee report, Volume 5, paragraph 246. Parliamentary Corporate Bodies Act, under which there is a corporate officer with whom the contractor contracts, and the detail, some of the detail, is set out in paragraph 246 on page 66 of the Joint Committee report. And there have been cases involving contractual disputes, a very lengthy case concerning, I think, the Norman Shaw building.
Footnote 245.
Thank you. Footnote 245. Indeed, the Harman case. Yeah. So that is the answer. The common law problems don't arise. Parliament has addressed it. The second issue that arose this morning was my Lord Brown's question about the Code of Conduct. We've looked at that. There is, so far as we can see, nothing of specific relevance to expenses. It's concerned with conflicts of interest.
Paragraph 14.
My friend wants attention to be drawn to paragraph 14 in relation to registrable interests.
No, allowances.
Sorry. Oh, paragraph 14 of the substance. Members should at all times ensure the use of expenses, allowances, facilities and services strictly in accordance with the rules. 14 in the fifth page of it. Strictly in accordance with the rules laid down in these matters, they observe any limits placed by the House on the use of expenses, allowances, facilities and services. And the third matter that I'm asked to draw to the attention of the court is that the representative of the Speaker of the House of Commons, who's here, has asked me to emphasise that he is here only to watch, to listen and to report back to the Speaker, and the Speaker takes no position in these proceedings. I hope that's consistent with what I said this morning, but that's certainly the position. My Lords, my Lady, reference was made yesterday by Mr. Fleming in answer to one member of the court to the Parliamentary Standards Act 2009. It was agreed below, both in the Crown Court and in the Court of Appeal, that the 2009 Act assists neither side in this case. There was certainly no suggestion in the appellant's written submissions that the 2009 Act assists their case. I don't rely on the 2009 Act, and I'm assured by Mr. Fleming that he still does not assert that there's anything in the 2009 Act which assists his case. I'm happy to seek to answer any questions on to try to answer any questions on the 2009 Act, but I don't want to waste the court's time unless the court is interested in any aspect of that legislation, which...
It's right. We had a few words. Yeah. My Lord, we don't rely upon the provisions of the Act, save for what it says, and the only point I was trying to make is that Parliament has now created the independent body which is outside the proceedings in Parliament. Well, that's the only point I was making.
Very well. Parliament has created an independent body which is outside Parliament, certainly.
Well, one construction is that that's just simply to clear up what is a grey area, which we have to resolve.
Yes. Well, if no other point is taken on that legislation, then I'm not going to take time on it unless the court would be assisted by me seeking to make any submissions. The court has my points in relation to Article 9. The claim form is an administrative act, both as a matter of substance and as a matter of the status of the person to whom the claim form is directed. It is designed to secure a personal benefit for the Member of Parliament. Nothing reprehensible about that, of course, but that's what it is. And it's a very long way from the free speech purpose of Article 9.
It's mostly to recompense the Member of Parliament for expenditure which he or she has made.
Oh, yes, indeed, in relation to parliamentary functions. But nevertheless, it is for the purpose of a personal benefit for the Member of Parliament. The money is being paid to them. Nothing wrong about that. Of course, Parliament thinks that's wholly appropriate, but it's nevertheless an administrative act a long way away from the free speech purpose of Article 9. There's then the broader principle of the exclusive jurisdiction of Parliament, on which my friend Mr. Fitzgerald made his submissions. Much of what I have said I submit is also relevant to this broader point. The case law, which identifies and protects the general principle of parliamentary privilege, falls into two categories. The first category of case concerns free speech. It concerns contributions by members of Parliament to debates in Parliament, which are covered by the free speech rationale and indeed by Article 9. But there's a second category of cases, and they are cases in which the challenge is to a decision made by Parliament itself or a decision made by the Speaker on behalf of Parliament. And examples of this category are Bradlaugh and Gossett, Volume 1, Tab 10. Not necessary at the moment, I think, to turn it up, but that's the case where the House of Commons passes a resolution which prevents the Member of Parliament from taking the oath and therefore contributing to parliamentary debates. And that's beyond the jurisdiction of the courts, even though the actions of the House of Commons are said to contravene the Parliamentary Oaths Act itself. Why is that? Because Parliament has taken a decision on a matter that is a matter of its own administration. Also, Burdett and Abbott, Volume 1, Tab 12, a decision is taken by Parliament to arrest a Member of Parliament. And the court has no jurisdiction in relation to the decision of Parliament itself. McGuinness, the more modern example, decision of my Lord Kerr, Volume 2, Tab 18, which the court saw yesterday, the decision by the Speaker on behalf of Parliament that members of Parliament who refuse to swear or affirm allegiance to Her Majesty cannot take their seats in Parliament, cannot use the facilities of the House of Commons. And the present case, of course, concerns neither, or my submission concerns neither free speech in Parliament nor a challenge to a decision of Parliament itself or a decision of the Speaker. My friend Mr. Fitzgerald emphasises the statement of principle by Lord Coleridge in Bradlaugh and Gossett. Can I take the court back, please, to Volume 1, Tab 10? And the principle can be found in Tab 10 at page 275. And it's in the first new paragraph on page 275. Picking it up in the fourth line, Lord Coleridge says, "What is said or done within the walls of Parliament cannot be inquired into in a court of law. He refers to Burdett, he refers to Stockdale. The jurisdiction of the houses over their own members, their right to impose discipline within their walls, is absolute and exclusive. Now, my submission is that this principle must be understood in the context of the case, and the context, as I have indicated, was the resolution by the House of Commons itself preventing the Member of Parliament from taking the oath. The first part of Lord Coleridge's dictum is plainly not the law if it is literally understood. What is said or done cannot be inquired into in a court of law. That would prohibit the approach in Buchanan, Lord Bingham's judgment for the Privy Council, that you most definitely can look at what is said in Parliament in order to understand the statement by the Member of Parliament outside the House that he stands by what he said in Parliament. It would pose great difficulties for Pepper and Hart. And the second part of the statement, the jurisdiction of the houses over their members, their right to impose discipline within their walls, is absolute and exclusive, cannot be understood literally, because if it is understood literally, it would prevent any prosecution of a Member of Parliament for any criminal offence that is committed within the walls of the Palace of Westminster. And we all agree at the bar that that is not the law, that there are many examples of offences committed by Members of Parliament within the Palace of Westminster which may be prosecuted in the courts. And this principle has been understood in later cases in the terms set out by Lord Brown-Wilkinson in the Preble case, which is volume 2 at tab 20. It's at page 332. At page 332 at letter D is where Lord Brown-Wilkinson for the board addresses this broader principle. He says, in addition to Article 9, tab 20, page 332, at letter D, in addition to Article 9, there's a long line of authority which supports a wider principle, of which Article 9 is merely one manifestation, that the courts and Parliament are both astute to recognise their respective constitutional roles. So far as the courts are concerned, they will not allow any challenge to be made to what is said or done within the walls of Parliament, and in these words, in performance of its legislative functions and protection of its established privileges. So there are limits to this principle. Lord Brown-Wilkinson then refers to the familiar cases, and he cites from Blackstone, on whose authority Mr. Fitzgerald places some reliance. The whole of the law and custom of Parliament has its original from this one maxim, that whatever matter arises concerning either House of Parliament ought to be examined, discussed, and adjudged in that House to which it relates, and not elsewhere. My lords, my lady, that principle, if understood literally, would prohibit all discussion and analysis of parliamentary affairs out of Parliament. It would plainly prohibit the analysis that one sees in cases like Pepper and Hart, in cases such as Buchanan, and the Joint Committee, when its attention was drawn to the Blackstone principle stated, and the reference is volume 5, tab 49, at paragraph 42, the Lordships have that, tab 49 of volume 5, and it's on page 18 of the report. Paragraph 42, at the end of paragraph 42, they say the oft-quoted statement of Blackstone in his celebrated commentaries, and then they quote it, is now accepted as being too wide and sweeping. And indeed, my lords, my lady, that must be the case. Now, we submit that this broader concept of parliamentary privilege, the exclusive jurisdiction of Parliament, cannot assist the appellants in the present case. It cannot assist because, by contrast with all the decided cases, I say all, I leave aside the possibility of exceptions in Herbert and in the Huckfield case, which I'm coming to, but with those possible exceptions, which I will deal with, all of the cases that have been cited to this court, and indeed all of the cases of which we are aware, are either cases where the court was being invited to entertain a challenge to a decision made by Parliament itself, or in McGuinness, the Speaker of Parliament, or they are free speech cases, cases directly concerned with the ability of the Member of Parliament to express his views on the floor of the House without liability, civil or criminal, following therefrom. And examples of that are, Preble itself, Hamilton and Fired, the Wasson case, which was referred to yesterday at volume 3, tab 35. They are all cases that fall within one of those two categories. And my friend Mr. Fitzgerald's submission that the courts cannot have jurisdiction without infringing this principle because Parliament itself could, and indeed has in other similar cases, exercised its jurisdiction over the MPs, proves far too much. Because it is plain, my lords, my lady, that if a Member of Parliament steals from the office of a colleague or damages the painting on the wall in the Palace of Westminster, or assaults his colleague in the bar, all examples which my friends accept are indictable in the criminal courts, the authorities of the House of Commons and the House of Lords would undoubtedly have jurisdiction, have power to entertain proceedings for contempt against those errant members of Parliament. And to like effect, and I gratefully adopt the point, my Lord Collins pointed out this morning that there is simply no equivalence between contempt of Parliament and exclusive jurisdiction. My Lord gave the example of the forced imprisonment of the Member of Parliament on his way to Parliament. One could give many other examples, such as interference, stealing letters sent by the Member of Parliament to the Speaker or to the committee. So we respectfully submit that the subject of the criminal proceedings in the present case is very far removed from the performance of the legislative functions of Parliament. It's very far removed from the established principles of Parliament, to use Lord Brown-Wilkinson's description. We're not here concerned with impugning any decision of Parliament itself, and we're certainly not concerned with preventing freedom of speech by an individual Member of Parliament.
So does this privilege have any content beyond that in Article 9?
Yes, my lord, it does, because a McGuinness-type case or a Bradlau and Gossett type case is not a free speech case. McGuinness has links, I suppose, with free speech, but it's not concerned with free speech. It's concerned with the decision of the Speaker that a particular elected Member of Parliament shall not be allowed to use the facilities of the House of Commons. That is not, I would submit, plainly within the scope of Article 9, but it's a decision by Parliament, by the Speaker on behalf of Parliament. Similarly, Bradlau and Gossett is closely linked with free speech, but it's a case about a resolution taken by the House of Commons. This elected Member of Parliament shall not be allowed to take the oath. And the court says, understandably says, Parliament has made a decision, and it's not for us to seek to impugn it. These are not, I would suggest, free speech cases. So I do accept that the wider privilege can and does apply in circumstances where Article 9 does not. But I would respectfully urge the court to be very careful indeed to give an approach, a recognition to this broader principle that travels outside the free speech basis for Article 9, and indeed the free speech basis for many of the exclusive jurisdiction cases, which is not also a case in which Parliament itself or the Speaker himself or herself has made a decision which is the subject of the legal proceedings. That is the submission. As I say, there are many cases which exemplify those principles. Ex parte Herbert, truly one of Mr. Herbert's misleading cases, is a case of which your lordships have a separate copy. It's not in the bundle. And the court will recall, there is in fact one of Mr. Herbert's misleading cases that addresses this very matter, which also repays reading. But Lord Hewitt, for the Divisional Court, at page 602, adopts the approach in the second paragraph that it was manifest to the magistrate, both from the documents which were before him and from the argument which was offered to him, that he was called on to deal with the House of Commons, acting by its teaching committee and the manager of its refreshment department. And there's a reference to Stockdale and Hansard. Here, as it seems to me, the magistrate is entitled to say, which is a perhaps curious way of dealing with it. It's not a Wednesbury reasonableness matter. He's entitled to say that in the matters complained of, the House of Commons was acting collectively in a matter which fell within the area of the internal affairs of the House, and that being so, any tribunal might well feel on the authorities an invincible reluctance to interfere, to take the opposite course might conceivably be in proceedings of a somewhat different character from these, after the various stages of those proceedings have been passed, to make the House of Lords the arbiter of the privileges of the House of Commons. Now, this judgment has been very much criticised as an unjustifiable extension of parliamentary privilege.
We were always led to think, as I recall, that the reason why the licensing laws didn't apply was that the Palace of Westminster was a royal palace, and that, in fact, when I believe, for constitutional reasons, that was changed, parts of it were retained as a royal palace in order to obtain the benefit, or continue to obtain the benefit of the exemption. But this authority suggests that that was complete.
Well,
myth.
Your Lordship is right, may I suggest, if Your Lordship looks at the separate opinion of Justice Avery, because his approach does proceed on, if I may say so, a more traditional approach of looking at the legislation and attempting to identify as a matter of construction whether the legislation was intended to apply to the House of Commons. That appears to be the approach that was taken by Mr. Justice Avery. I won't take time reading it. What is apparent is that this judgment has been much criticised. The criticisms are collected, they're summarised in the Joint Committee report at Volume 5, Tab 49. And I invite the Court's attention, please, to page 67 of the Joint Committee's report, tab 49 of Bundle 5. And it's paragraph 249 under the heading Precincts of Parliament. It follows on from the passage to which my Lord Clerk drew the Court's attention earlier, distinguishing between resolutions and orders, which are proceedings in Parliament, and implementation, which is not. And at 249, unfortunately, says the committee, the need to draw a dividing line has been obscured by the decision in the A.P. Herbert case. The sale of alcohol without a licence was a criminal offence, motivated no doubt by a desire to be circumspect and not trespass upon matters properly belonging to Parliament. The Lord Chief Justice decided the courts would not hear a complaint regarding sales of alcohol in the precincts of Parliament without the licence because the House of Commons was acting collectively in a manner which fell within the area of the internal affairs of the House. And that's the point. Contrasted with the present case, where there's no challenge to the collective decision of the House of Commons. But even that, at 250, this decision, which has not escaped criticism, has spawned difficulties and anomalies, mainly but not solely in the field of employment. Statutes treated as not binding on either House on the basis of the decision have included, and there's examples given, many of these acts have been applied voluntarily, but the criticism remains that the lawmakers are exempt from the laws they make for everybody else. This criticism is forceful because these acts cover activities far removed from core activities of Parliament. Parliamentary privilege exists to enable members to discharge their duties to the public. It cannot be right that the privilege should have the effect that Parliament itself, within the place it meets, is not required to comply with its own laws on matters such as health and safety, employment, sale of alcohol. Whether the decision in the A.P. Herbert case was in accordance with earlier cases is not a matter we need pursue. The decision has never been considered in a higher court until now. For the purposes of this review, it is the practical consequences that matter. We consider the practical consequences are not satisfactory, and they recommend the enactment of a provision to the effect that the privilege of each House to administer its own internal affairs applies only to activities directly and closely related to proceedings in Parliament. We recommend there should be legislation clarifying that as to activities which are not so related. There should be a principle of statutory interpretation in the absence of a contrary expression of intention. Acts of Parliament bind both houses, etc.
Read to the end.
Etc. Yes, the legislation could usefully include examples of internal affairs on each side of the line We envisage this provision would operate for the future. A sweeping retrospective change applying to all existing legislation would have unforeseeable practical repercussions for the future. Whenever Parliament is to be exempt, a reasoned case should be made out and debated as the legislation proceeds through Parliament. So putting it at its highest, this is a very dubious authority, and in any event, it is an authority which proceeds on the basis that the Lord Chief Justice understood the challenge to be a challenge to a decision of Parliament in that the relevant committee had taken a stand on the particular matter.
Whom was the Attorney General representing? Was he in this case? And he appeared and he argued in favour of the privilege or whatever you call it.
Well, he's representing the magistrate.
I'm just asking. Yeah.
Yes, I mean, all we're told at page 596, he showed cause against the rules.
Yeah.
He was either, I suppose, appearing for the magistrate, or if the magistrate did not appear, he was appearing as Her Majesty's Attorney General to assist the court. But I take your Lordship's point. There's no indication of the position of the status, the particular client he was representing. So there it is, A.P. Herbert's case. As I've submitted, there are only two cases that we are aware of that have been cited to the court which do not fall within the two categories that I've identified, free speech and challenges to decisions of Parliament or the Speaker. One is A.P. Herbert, a dubious decision, much criticised, which in any event is understood as being a challenging court to a decision of the Catering Committee. The only other case that has been referred to is the Huckfield case, which is referred to in my friend's written submissions. This was the case about the member of the European Parliament who was prosecuted for allegedly making dishonest expenses claims to the European Parliament. The Crown Court, Mr. Justice Moreland, held that to prosecute would be a breach of the privileges of the European Parliament, or at least a breach of the exclusive jurisdiction of that Parliament. But the divisional court, Lord Justice Leggett and Mr. Justice Pill, took a different view on the merits, and their decision was then overturned in the House of Lords, not by reference to the merits, but by reference to the divisional court lacking jurisdiction to review the decision of the Crown Court. So that case, in my submission, is not going to assist this court at all, either way. So we respectfully submit in all the circumstances that my friend Mr. Fitzgerald's submissions take this matter no further forward. We say it is the case in relation to Article 9, as it is in relation to exclusive jurisdiction, that for this court to recognise privilege in the context of this case would go well beyond the established case law, focusing as it does on free speech in Parliament and decisions of Parliament itself or the Speaker, with these minor possible exceptions, dubious exceptions. My friends have referred to no judicial decision which suggests that parliamentary privilege applies to the otherwise criminal conduct of an individual MP, which is not a statement on the floor of the House, or at least a substantive contribution to the work of a parliamentary committee. We respectfully submit that the true answer to the question posed by my Lord Collins yesterday afternoon is that all the cases, with these two minor exceptions, Herbert and Huckfield, do relate to free speech in Parliament or attempts to challenge decisions of Parliament itself or the Speaker of Parliament. We respectfully submit that to recognise privilege in this case would conflict with the principles stated by the Joint Committee as to the need to confine privilege, and we respectfully submit that to recognise privilege here would conflict with the views of Parliament itself, which deserve considerable weight. They are certainly not binding on this court, that they are highly material when the court is being asked to expand what has hitherto been the limits of parliamentary privilege, and when that expansion raises important issues about competing public interests. For all those reasons, subject of course to any other matters that the court may wish me to seek to deal with, and subject to being told from behind or any other matters, that is what I wanted to say to the court, by way of submission.
Thank you, Lord Planning. Mr. Segan? Yes, Mr. Planning.
Lord, we were intending to reply in the same order that we made our submissions. Lord, the preliminary observation is that the arguments are now so clearly set out in the written submissions and in the oral submissions that there is little to add by reply, and having said that, I will then say something in reply. But what I won't do is go over the submissions already made. The very last point that the learned friend mentioned is that we can't point to a case where there has been a situation like this considered by here the highest court, indeed any court, either in our favour or at all, and that's because it hasn't arisen before. And these are novel submissions which we accept, but important in that they are made against a background of an existing and clear privilege. Lord, I'm going to focus on Article 9, and in Article 9 terms, the central underlying issue remains, and I rephrase it, it's the same as I said before: does the allowances scheme fall within proceedings in Parliament? In the phrase, and debates or proceedings in Parliament in Article 9 of the Bill of Rights. If it does, if the allowances scheme falls within those words, then for the reasons we have developed, the Crown's attempt to exclude from those proceedings the central document, ACA 2, the application form, is not only wrong for the reasons we've given, but difficult and could lead to very odd consequences. And could I just explore those for a moment? It is, we submit, clear that the submission of the claim form by a member direct to the member's estimate committee or direct to the Speaker would bring the document within proceedings for the purposes of Article 9.
Can you
yes,
inform us a little more as to what actually happens? The Estimates Committee does what? Where do the estimates go? And
The trickle down to the fees office, is that what your Lordship was asking me, or what the claim form itself?
Well, it has a sort of feeling of some sort of funding process.
I'm sorry.
And I'm not quite sure how the thing works. There must be some estimate in advance of the provision of funds to Parliament, but maybe each year you build up an estimate based on experience in the year that's gone by or something like that.
Your Lordship will see me leaning towards and hoping to find the immediate answer in Erskine May. Erskine May is not always as easy to follow as perhaps it should be. On the make-up of the estimate approach to funding of Parliament, it's very good.
Yes.
Lord, could I just find somebody to give me the page reference?
Yes, it would be very helpful if you could find the
rather
page
than
to us to
attempt
look
to
at.
summarise it.
Thank you.
What you end up with is a position whereby Parliament is approving a budget. Not a budget, it's called an estimate. It's an amount of money that can be used to defray, for want of a better word, expenses, allowances. It also will include pensions and payments. It's those three broad categories. And then there's
Payments.
Payments. Pensions, payments in terms of monthly pay to the members themselves. So you'll have categories, salaries, yes. Salaries, pensions, the resettlement allowance to which there's been reference, and also this question of allowances stroke expenses. What I don't recall is whether the whole process of allowances is separately regulated or there is an overall estimate which is managed, for want of a better word, by the members' estimate committee. My recollection is that the whole process is regulated by that committee, which includes as part of its constituent the Speaker. The Speaker is a member of the members' estimate committee. Well, I'll check, and if necessary, then we will photograph and send the photocopy and send you the relevant pages. But what I was more concerned with was the mechanisms of the implementation and administration of the system. And that is very closely regulated by the Green Book, to which there's been reference. And you have in the appendix 3 versions. And the reason that you have 3 versions is it covers years in which the allegations against the former MPs are made, 2005/2006. It also includes 2009. Which only covers, I don't think, it may not cover any of the charges. It didn't cover the charges for Mr. Chaytor, who I was one time only representing. But what you have is a very closely regulated and controlled scheme, and the process is that your claim form goes into the fees office, which is the delegate for Parliament, and if there is any ambiguity, uncertainty, a question of interpretation of the rules, the Green Book or whatever, that would go off either to the Members' Estimate Committee or to the Speaker. I haven't clearly got the route. But what is clear is that it isn't merely a mechanism of handing a form to the fees office official, and that's the end of the process. And the reason I wanted to start with this in reply is that my learned friend has focused repeatedly and understandably as a well-experienced advocate on the act of filling in the form and of submitting the form, and he says to the court, well, that is not the MP carrying out a core function. This is the MP merely making a claim. That is, greatest of respect to him, wholly to miss the point, certainly the point that we're trying to make. What we start with is understanding whether or not these are proceedings in Parliament, and that's the administration, creation, regulation, enforcement of the allowance scheme. This is all in Article 9. It's when we get to that stage, we then ask the next question, is this form part of those proceedings, or is it just a peripheral, almost irrelevant document? And my learned friend only focuses on the document. The reason that I wanted to mention what if it was submitted direct to the MEC, the Members' Estimate Committee, or direct to the Speaker, is that the Court of Appeal appears to have accepted, although not entirely clear, in paragraph 74, your Lordship will recall, that would make a difference. 75. a claim for expenses is not submitted to any other member of the House, nor even to the Speaker or Lord Speaker, or to his or her office. It is submitted to an official of the Fees Office. And although that official is appointed by and is agent of the House, he is not officiating in connection with the business carried on with the Chamber or within a committee. So the Court of Appeal, in response to submissions made by my learned friend on behalf of the Crown, is distinguishing how the form is delivered, or the route by which it finds its way into the system. Well, again, we say that that's really the wrong approach, because there would be rather odd consequences. And that's what I was just going to turn to. Accepting that the submission of the document direct to the Speaker would fall within proceedings, or if submitted direct to the Members' Estimate Committee, it would fall within the proceedings. The oddity is at least as follows. What if there was a fairly nominal or neutral claim form, not supported by invoices, not supported by documents, or indeed just documents?
When you say submitted to the committee, is that because there's a reference to other member of the House? Are you imagining the committee is made up of members of the House?
Well, Lord, it wasn't clear what was meant by any other member of the House, but I've assumed that must mean a committee made up of members of the House.
Yes. Because
there's no single member of the House that would be involved. That's what I'm assuming is meant in paragraph 75.
And the MEC is necessarily a committee of the House?
Necessarily a committee of the House, and made up of members and the Speaker. So it's a slightly unusual committee to that extent, that it has the Speaker as an integral part of the committee, and again, if I recall the sequence, you can refer decisions off to the Speaker from the Members' Estimate Committee. So he has feet in two camps, or his own camp in the committee. What I'm trying to tease out is whether or not the submission of a form direct to the committee would be covered by Article 9, and if it is, with what consequences, and whether if a different form is submitted to the Fees Office, then there's a referral to the committee, or there's an appeal to the committee, and different forms are submitted. And my learned friend's analysis simply does not begin to grapple with that problem, and appears to be suggesting that a different legal order, a different legal consequence applies if the form is submitted simply to the Fees Office rather than being put into a committee. And it's for that reason that we attempted in paragraph 61 of our grounds of appeal to have this sequence, starting from a statement in the House down to a delegated position where you go through an increasing level of bureaucracy. Learned friend, as with the Court of Appeal, says we don't need to deal with that analysis because we are only dealing with the circumstances. But the circumstances themselves, must we submit, have to be understood, and there could be both unfair and absurd consequences if there is to be a different treatment for a form which is submitted direct to the committee, direct to the Speaker, or submitted to the Fees Office. The answer may be that none of these proceedings are protected by Article 9. And that's one of the reasons we gave that descending list of examples in paragraph 61. And the other reason why we gave the court that list of ordinary crimes. Because the central issue that we are struggling with and trying to present to your lordships and my lady is, are there crimes, so-called ordinary crimes, committed orally or committed by written statements that would be privileged if they took place in the chamber, in the committee, or to a subcommittee, or to a delegate. And all of that has simply not been addressed at all by my learned friend, and we re-emphasise it in reply.
It's not a physical link. I think you've made that clear on both sides. So what is this? Is it an employment link? If the I think we're going back slightly to something put to you in opening, but if this had been subcontracted out, so it wasn't an officer of the house, and the contractor was given authority to settle, and at the end of the year simply accounted for the balance, where would you put that? Would you say that, since it doesn't matter presumably whether it takes place in the house or not, is it the fact that the officer is an employee of the house that is critical and a subcontractor would be different?
Oh, my Lord, it is again, not as simple as that. When that question was first raised, that's why I turned to the 2009 Act and the independent IPSA that was there created. What we're looking at is not merely an officer being an official of the house, just described as a servant of the house. The fees officer is representing the house in the relationship between the MP and the committee, the Speaker, and then the full House. So it's all part of one scheme. Now, if you interpose a wholly independent contractor, that link may be broken, but it may not. It may be that if you interpose a contractor that is merely performing the administrative task of the fees office itself, the chain is the same. And that's why, again, looking at the 2000 Act is only relevant to this extent, that it shows that their Parliament was had achieved the break by creating a wholly independent body, and in Section 1 saying this has nothing to do with or doesn't take any force away from Article 9 of the Bill of Rights. So it's still leaving in place all of our arguments in the pre-IPSA world.
Where would we find the best description of the system, if there is one, or any description of the system?
Well, again, insofar as there's a description, it's in the Green Book itself, and it may be that instead of giving the
Perhaps I've lost my reference to the Green Book. What's the relevant reference to the system as stated in the Green Book?
The reason I was hesitating is the extract you get in the Green Book, they're in the appendix, my Lord.
I wasn't quite sure which was the Green Book.
I'm sorry. If you go to the appendix... If you go to the appendix beginning at page 82 is one of the Green Books, I think that's 2005. What we haven't provided for you in order to save a few trees was the whole of the Green Book for 2005, 2006 and 2009. It may be that it would be useful to have a copy of one of the Green Books, because that describes the whole process. You should have, my Lord, also in the Statement of Facts and Issues, at the appendix...
It's paragraph 16.
I think it's 16. We had an agreed description.
Yes, paragraph 16 is.
Yes, tells you. Lord, it's paragraph 6 onwards on page 4 of the agreed facts. The Members' Estimate Committee is described, and then the administration of allowances is described in 9 and 10 very shortly, and then the Green Book is summarised, leading to the additional cost allowance, the ACA, which takes you through to 17, where there's also reference to the IEP, the incidental expenses provision. The importance of the Green Book is, I can perhaps jump to another point made by my learned friend, is if there is a referral or an appeal from a decision of the Fees Office whether or not to allow a claim or to say this, that he needs a clarification of the meaning of the rules, then the rules will be interpreted by the Members' Estimate Committee, if necessary by the Speaker, and then, if necessary, there will be amendment. This becomes quite important for at least one of the charges. Mr. Chaytor is charged that he has made a claim in relation to a property which was owned by his mother, and that was said, in part, to be contrary to the requirements of the additional costs allowance, which is at page 99. This is the Green Book for 2006. ACA must not be used to meet the costs of a mortgage or for leasing accommodation from yourself, a close business associate, or any organisation or company in which you or a partner or family member have an interest, or a partner or family member. So what you have there is merely an example of a rule that may require interpretation and application. So what you have is, if you can overview the picture, you have a claim for an allowance which has to be claimed in accordance with the rules. See not only the Green Book, but see the Code of Practice, the Code of Conduct, and you've had the reference to the relevant paragraph. The Code of Conduct itself being created and approved by the entire House, and you then will have the possibility for interpretation of the rules. And all of this suggests, and we say strongly suggests, that we are looking not only at a wholly internal process, but a process which is part of the proceedings in Parliament. And the point that my learned friend was making this morning, in answer to a question, is, well, what if this went to court and there happened to be a need for an interpretation of the example I've given you is 3.3.3 on page 99. Another example would be the meaning of parliamentary duties, which is on page 113, because the allowance can only be paid in relation to the discharge of parliamentary duties. Well, let's assume just one of those came before the court. My learned friend, Lord Panic, unsurprisingly says, well, the courts are used to interpreting statutes. They're quite good at interpreting documents. They can interpret the Green Book. In the greatest of respect, no, they can't. The Green Book is different. It is not a statute. It is part of the internal workings of Parliament. And then you could have truly that conflict that we've been talking about, where the Members' Estimate Committee says this, it does fall within A or B, and a court saying, no, it doesn't. And Lord, that answer from my learned friend was a clear indicator of the Crown's refusal to grapple with our submission. We're talking about a scheme, not about a single document. Well, that's probably enough by way of reply. It's repetition of what we say in our written submission. But I wanted to start with that because it's important to work out where we're going and what would happen if our submission is rejected, or could happen. The next question that came up as part of the central part of our submission, which we were expecting to be addressed by my learned friend, was the kind of proceedings that would be covered by Article 9, but that are not debates in the Chamber or are not debates in the committee. We gave two examples. One was the Commissioner for Standards, and the other was the leg review.
The other was what?
The leg review, my Lord, to which one can also add McGuinness. My learned friend, Lord Panic, said in relation to McGuinness that was not an Article 9 case. Well, that may come as a bit of a surprise to Lord Kerr, whose judgment is focused on Article 9. This is entirely an Article 9 case, but it's Article 9 attached to the speech made by the Speaker when announcing her decision. that becomes part of proceedings, but that merely begs the next question. What happens to statements made to the Speaker in the course of what becomes proceedings? Similarly, with the Commissioner for Standards Privileges, when a statement is made to him or her, is that statement protected, or does it have to be described as the MP merely protecting themselves, not discharging their function, or it's merely a repeated claim for money? Well, again, my learned friend is really getting it the wrong way round. So can we then just look at the leg review? Because, again, my learned friend fails to grapple with the submission we make on the leg review. The review by Sir Thomas Legge was authorised without doubt by Parliament, and he is outside Parliament, so he's brought in by a request from the Members' Estimate Committee and the Speaker, and he then reports back to the House, so he's within the House. But what he's doing is reviewing all of the claims in the same way that the Members' Estimate Committee could have reviewed claims, in the same way that the Speaker could have reviewed claims, in the same way the Fees Office could have reviewed claims. And there is an ongoing review. Now, if one understands that that is what Sir Thomas Legge is doing, and that it was then felt necessary to create an internal appeal to Sir Paul Kennedy, you have another example of proceedings in Parliament. And the point that we were making, which again my learned friend has failed even to address, is that when documents are put into the review by Sir Thomas Legge, are they protected by parliamentary privilege? Yes, they are, for the reasons I gave you yesterday. But if they are, what's the difference? What's the distinct difference between a form submitted to Sir Thomas Legge and a form submitted to the Fees Office, which is acting as a delegate of the House? And we say there is no difference.
So if somebody put in a forged document to Sir Thomas Legge, you say it's clear to you that...
Absolutely clear. Absolutely clear that that is protected unless, and this is really at the heart of everything we've said, unless Article 9 doesn't apply to ordinary crime. And that's the, I say $100,000 question, but it's perhaps the wrong way of putting it in this court. But if Article 9 does deal with the dishonest statement, the statement that is motivated by malice, the statement that offends racial laws or other laws, then it must also cover the forged statement. And no reason for me to criticise my own friend. We've known each other for many years. But again, one can't help but notice that the list of crimes, the ordinary crimes that we prepared, have not been criticised, not been suggested that they are not protected in the House. So if they are protected in the House in the course of a debate, are they protected in the course of a committee? Yes, they must be. If they are protected there, it's because of the words in proceedings in Parliament in Article 9, and we're back to where we started. How far does proceedings in Parliament go? So, my Lord, in answer to my Lord Brown's question, if there's a forged document put before Sir Thomas Legge, it is excluded from the criminal law. It may well bring all sorts of consequences in the House. It may well bring the kind of findings that you've seen in the Baroness Udin report in the House of Lords. But this is not for the criminal courts. And if it's not for the criminal courts in Sir Thomas Legge's inquiry, then it certainly can't be in the normal process, because there is no fundamental difference. Lord, that's what I wanted to say about Sir Thomas Legge, which takes me on to the question of ordinary crime. My learned friend in his submissions did not clarify his reliance on the 1831 Committee of Privileges and Standards, which is part of his written argument, which suggests that indictable offences are not protected by privilege. Lord, I'm assuming that that is still part of the Crown's case, and if it is, could I just re-emphasise to your lordships, as with the Wellesley case, they are nothing to do with Article 9. This is dealing with a different privilege, the privilege against arrest, the privilege that the MP in Wellesley was dealing with, dealt with in the textbooks in a different section, dealt with in Hallsbury in a different area. So this is the freedom of, it's called privilege of Parliament in relation either to arrest or attachment. And the best example, one of your lordships, maybe your lady, mentioned the case of Wilkes yesterday, and I've really forgotten what happened to Wilkes, but if I can just mention to you that the John Wilkes case in 1763 is a very good example of why freedom of arrest doesn't apply to indictable crimes, because there were two stages to that case. First of all, John Wilkes claimed privilege of Parliament. He could not be arrested. And he was not only arrested, he was tried and sentenced for seditious libel when he criticised the king. And the reason that he could not rely on privilege of Parliament is that what he said was not in Parliament. He wrote a book which I failed to find on Amazon called The North Briton. Having seen a summary in the 1770 report, I can't wait to get a copy, but it was clearly offensive of the king, and he was tried and convicted of an indictable offence, and that's because what he was doing was outside Parliament. So the Wilkes case is a good example, as is Wellesley, of a crime committed by a Member of Parliament outside the protection, so outside Article 9 of the Bill of Rights, and then they are, to use a phrase, fair game for the prosecuting authorities. And the Crown really has to grapple with this issue because they have first to understand what is being protected by Article 9, and we say it does protect ordinary crime. We have accepted and conceded that it doesn't protect the damage to the mace by Ron Brown, even though he was not only not prosecuted, when an attempt was made at a private prosecution, the DPP stopped it. But that's an example, and we mentioned the assault on the then Home Secretary. One of the reasons we accept that they are covered by ordinary crime is we don't need to go there, and Mr. Justice Stevens said that ordinary crime was not covered, referring to the Sir John Eliot case. Well, so, having dealt with those examples and resisting the temptation to deal with the theft of a library book from the House of Lords library by a member of the House of Lords who could be researching the very topic that is covered, or, for example, would want to tear the page out that was relevant, or even defacing the judgment of another member of the House of Lords by expressing a verbal opinion, would that be covered by parliamentary privilege? It may be, but fortunately I don't have to deal with it. Could I then just go through one or two miscellaneous points and then stop my reply? It's really to pick up points that have been raised by my learned friend in his submissions that are specifically on Article 9. One is the repeated reference to the views of the Joint Committee in 1999. We also say that it's a very useful and interesting document, and we put down a small gauntlet in relation to paragraph 38 of the Joint Committee's report as to whether or not the Crown accepted that paragraph 38 is a good description of the legal effect of Article 9. In more precise legal language, it protects a person from legal liability for words spoken or things done in the course of, or for the purposes of, or incidental to any proceedings in Parliament. So it's slightly expanded wording from the strict language of Article 9, but we say that it's a correct analysis, and we note that there's no specific reference to it. whilst on that document, my learned friend made several remarks in relation to the joint committee. There's only one really that I wanted to deal with. And there's a reference, first of all, to page, paragraph 110. This is on page 34 of the report. Article 9 provides an altogether exceptional degree of protection. In principle, this exceptional protection should remain confined to the core activities of Parliament unless a pressing need is shown for an extension. We don't disagree with that or suggest that that is the wrong approach. And we're not suggesting that there should be an extension. What we're suggesting is that there should be a correct reading of Article 9. So when we get to the repetition of that phrase in a separate section, the learned friend refers to paragraph 241. Yes, it's 241 on page 64. This is dealing not with Article 9, but dealing, if you go back to page 62, with control by Parliament over its affairs. And you'll see paragraph 229, parliamentary freedom of speech, guaranteed by Article 9, is one facet of the broader principle that what happens within Parliament is a matter for control for Parliament alone. Such matters will not be reviewed by the courts. And then you get to paragraph 240 and 241, the right of each house to administer its internal affairs within its precincts. And then from Bradlaugh and Gossett, you get to the last sentence, the last two sentences upon which my learned friend relies. Here as elsewhere, the purpose of parliamentary privilege is to ensure that Parliament can discharge its functions as a legislative and deliberative assembly without let or hindrance. This heading of privilege best serves Parliament if not carried to extreme length. So taking the penultimate sentence as also applying to Article 9, we don't find any discomfort there, because the allowances scheme, particularly in a modern Parliament, is to ensure that Parliament can discharge its functions as a legislative and deliberative assembly, because, as we look through the allowances scheme, why it was created, first of all with travel in 1911 or 1921, you'll see the history in the concordance of resolutions in volume 5. It's there so that MPs can be there and can be in Parliament. And if they are not there, there can be no deliberative or legislative assembly on behalf of all peoples in the United Kingdom. And Parliament has no existence save by its members, unless it also has its temporary existence through its officers. So you need, in a modern democracy, an allowance scheme, because the members of Parliament are not paid enough to cover allowances, and they're not all rich enough to travel by chauffeured limousine. So there's no difference in principle between some of the other things that Parliament does to ensure that it can discharge its core functions. And for those reasons, we say that there's nothing to be gained from the Joint Committee report that determines this case saved, possibly either in our favour because of paragraph 38 or some other observation such as the one I've referred to, or it's neutral. But I think there are only one or two other points I wanted to make. I picked them up as we were going through. But Lord, repeatedly, as one goes through whatever notes you have of my learned friend's submissions, you'll see that his theme, his tactic, is to try and isolate the ACA2 form from the scheme, so that it is not part of the functions of the MP, but of course it is. The vital public interest argument then was put forward that one must keep in mind the principles explained by Lord Bingham, for example, in Sharma, and the reference you have already, Volume 3, Tab 31, at page 786. The facts in Sharma are illuminating. Some of you will remember having been involved. A very different situation. But the paragraph upon which my learned friend relies has the caveat, subject to any immunity or exception provided by law, which rather, putting it crudely, begs the question. There's nothing to assist my learned friend in Greenway or Wellesley for the reasons we've submitted, which then takes us to Pepper and Hart. What is the purpose of Article 9? Again, without taking you to it, certainly not in reply, my learned friend refers to page 638 and a few lines from the judgment of Lord Brown-Wilkinson. We invite your Lordships, my lady, to read 638 and 639 together, also referring to the Church of Scientology case. Lord, the rest of the points really follow. We've made our submissions on the Register of Members' Interest. We say it's absolutely no difference. Of course, that's dealing with what the member would say in the House or in a committee, but it is part of ensuring that the House can conduct its legislative and deliberative functions. Lord, the rest really falls away, because if we are right in our central point that the scheme falls within proceedings, then the rest should follow, unless, which perhaps is the slightly hidden agenda, that Article 9 doesn't apply to any allegation of dishonesty, which we say can't be right. So unless I can assist the court further, that's all I wanted to say in reply.
Thank you very much, Mr. Fleming.
Thank you, Mum.
Yes.
Well, my lady, the submissions of my learned friend Lord Panic founded at one stage, and the Court of Appeal did too, on the principle of equality before the law. We say that the principle that is relevant is the principle of equality. That's to say, you treat like cases alike and different cases differently. And it is important here that the exclusive jurisdiction has both advantages and disadvantages to MPs. They are treated differently under the law as it is at present. And the court has already seen there's a unique disability, that they can be condemned and punished without any remedy in the ordinary courts. And that's a consequence of the exclusive jurisdiction. And they can be deprived, as the court has seen, of their pay, of their pensions, of their resettlement grants, and that is without any recourse to the ordinary courts for a remedy. So they're not treated like any ordinary citizen. They're not given equal access to the ordinary courts in relation to these matters. And therefore it's perfectly just that they should be, that exclusive jurisdiction should have, in certain situations, be the only jurisdiction that deals with them. And the situation that my learned friend advocates is one in which they're deprived of any remedy in the ordinary courts for the denial of proper payments. They simply have to live with the internal system of Parliament and what system they're given, and you've seen the letter that was sent to Mr. Elliott Morley. So they're deprived of that remedy in the ordinary courts when their proper payments are denied, but they're exposed to punishment by the ordinary courts when they're alleged to make improper payments. And we respectfully submit that demonstrates the unfairness of that if you've got exclusive jurisdiction, it will have consequences both beneficial to in certain situations and disadvantageous to in other situations, the MPs. But you simply can't say, in the light of that, oh, they must be subject to the same processes as other citizens. They're not. Exclusive jurisdiction marks them out as different and has both pros and cons. And there's nothing unjust in upholding that system of exclusive jurisdiction consistently, rather than saying, when it comes to punishments, send them over to the ordinary courts; when it comes to remedies, keep them within Parliament. And that is what my learned friend, Mr. Lord Panic, has been submitting. Just one general point. My learned friend analysed the exclusive jurisdiction cases that we have relied on, and he said that with two exceptions, that's to say the Herbert case and the Hupfield case, which are not insignificant cases, they all fell into two categories, either freedom of speech cases or cases in which the issue was the jurisdiction of the courts over the decisions of Parliament itself. But what we say is you've got to look at the underlying principle. There is an area, the underlying principle is that there's an area over which Parliament has exclusive jurisdiction. And it may not have been tested in this situation, probably because there's never been a case which has been referred to the courts on this sort of issue. But if one looks in Volume 2, at tab 15 in the Hamilton case, it is quite clear that the general principle, it arose, of course, in a free speech case, but the general principle was not just an Article 9 principle. If I can take the court to page 402F, one sees there that Lord Brown-Wilkinson recites the wider principle at 402F2H, and then refers to the wide scope of parliamentary privilege that's been discussed. And then at 403, it is, in my judgment, firmly established that courts are precluded from entertaining in any proceedings evidence questioning designed to show that a witness is deliberately misled Parliament. And then he goes on to make a point which is entirely to do with exclusive jurisdiction of Parliament. To mislead Parliament is itself a breach of the Code of Parliamentary Behaviour and liable to be disciplined. For the courts to entertain a question would be to trespass within the area in which Parliament has exclusive jurisdiction. Now, he could have just said that the matter is simply settled by Article 9 and the interpretation of Article 9. Full stop. He doesn't. He derives a separate justification for it from the exclusive jurisdiction, the principle of which has been cited at 402F to H and applied at 403G to H. And it's quite clear that these are two separate grounds on which one can reach a conclusion. And in reply to my Lord Clerk's question, that's to say, what does it add? What we respectfully submit is it may be that in many cases it reaches the same conclusion. But the point about the exclusive jurisdiction argument is it does not depend on the interpretation of the word proceedings. And therefore it is an alternative but equally freestanding and sufficient way of arriving at the same conclusion. And the general principle we submit is relied on quite independently of Article 9 in that recent case, arising, of course, in a facts involving free speech, but as a separate and freestanding basis for saying this is a matter for Parliament, and for Parliament alone, because it has exclusive jurisdiction to punish for contempt in this type of case. And apart from that, the Court has our submissions about the underlying principle. In our speaking note, it's at 1.10 to 1.11. At pages 6 to 7, but we do say that this is an area governed by the exclusive jurisdiction and the penal code of Parliament itself. Many of the submissions, just picking up, may apply to both points, but I make them to assist the Court. Firstly, Lord Panic characterised the conduct of the MPs here as an administrative act to obtain a financial benefit. We respectfully submit that that's a mischaracterisation. What it is a statement to Parliament to obtain a necessary payment for the discharge of parliamentary functions. And it's made by a Member of Parliament in his capacity as an MP. And the distinction between the fraudulence in the cafeteria that my Lord Mance put to us this morning is that there's no, in that case, the cafeteria fraudulence, there's no accompanying formal declaration by the MP to Parliament. There's no relationship between the MP and Parliament. Now, the next point my learned friend, Mr. Panic, made is this. He relied on in the context of Article 9, on the formulation by the Joint Committee at paragraph 247. So that's at tab 49, volume 5. But actually that formulation is a formulation made by the committee in the context of exclusive jurisdiction. And one can see that because it refers to proceedings in Parliament. And it says the dividing line between privileged and non-privileged activities of each house is not easy to define. Perhaps the nearest approach to a definition is that the areas in which the courts ought not to intervene, i.e. exclusive jurisdiction, extend beyond proceedings in Parliament, but the privileged areas must be so closely and directly connected with proceedings in Parliament that intervention by the courts would be inconsistent with Parliament's sovereignty. So this is not about Article 9, this is about exclusive jurisdiction, and one can see that if one goes back to paragraph 240. The heading here is the right of each house to administer its internal affairs within its precincts, and its citation from Bradlaugh and Gossett. And obviously this isn't a definition of Article 9 because it uses the word proceedings in Parliament, which is, and it says, to intervene, extend beyond proceedings in Parliament, the privileged areas must be so closely and directly connected with proceedings in Parliament. And that perhaps is an answer, that's a wider approach, an exclusive jurisdiction that extends beyond proceedings in Parliament to things that are closely and directly connected with proceedings in Parliament. Now, it is our submission that these are proceedings in Parliament, but in any event, the declaration at the heart of this alleged misconduct is closely and directly connected with parliamentary business, and the declaration made is a declaration to Parliament. So we respectfully submit that paragraph 247, far from assisting my learned friend, actually supports the argument that there is a wider jurisdiction, exclusive jurisdiction, and that these three appellants come within that. The third point my learned friend made was that to be proceedings or to attract the exclusive jurisdiction, they must involve the conduct must involve the core functions of Parliament or parliamentarians. But we respectfully submit that the payment of expenses by Parliament is part and parcel of the core functions of Parliament. Now, my Lord Mance put the point, doesn't it matter to some extent at what level the decision is being taken? We respectfully submit 2 points arise out of my Lord Mance's question. Firstly, we would submit that the level cannot be determinative. It's the nature of the decision and not the character or seniority of the decision maker that determines the applicability of the exclusive jurisdiction. Moreover, we make this second point, that the form is not a statement to a particular official at a particular level of seniority. It's a statement directly to Parliament. And on both those grounds, we say that one cannot, as it were, exclude its characterisation as proceedings in Parliament, or the applicability of the exclusive jurisdiction by reference to the character of the decision maker or his level of seniority. And then finally, my Lord, my Lady, there are certain submissions in relation to what was part 5 of our submissions, the question of has Parliament evinced by its actions an approach to these matters. My Lord Phillips raised the question of the fact that there must have been some level of cooperation with the police investigations for matters to have got so far. And just to assist as best we can, it's right that the Fees Office did hand over the relevant documentation to the police, but before doing so, they sought the consent of the individual MPs and their lawyers, which was given. And then on interview by the police, they attended, but objected on the grounds of privilege and exclusive jurisdiction to answering questions. As I understand it, at trial, if there is a trial, it would be proposed to call a representative of the Fees Office. There would be little alternative.
Sorry, I missed that last bit. It's proposed to call a representative.
No. The prosecution would propose. The Crown would propose to call a representative of the Fees Office. And indeed, but what we respectfully submit is the level of cooperation of handing over papers after getting the consent of the MPs does not indicate some waiver of jurisdiction. It's not a coercive act. It's, do you mind if we hand these over? For all they know, the police might say, well, having read that, that's it. We won't trouble you anymore. So that cannot be some kind of deemed waiver or consent, or saying there's that there is no exclusive jurisdiction. And the next point is, my learned friend Lord Panic said that it's unrealistic to suggest that Parliament has not taken a position. He said that Parliament, through the Speaker and the committees, has taken a position, and that is the reality of the situation. We respectfully submit it's really equally unrealistic to discount the context of such acquiescence as there has been here. It's acquiescence, firstly, in the face of massive public and political pressure. And then, in relation to recent matters, one can't discount the fact that there have been two rulings of the courts, we say wrong rulings, but rulings, saying that there is no privilege and there is no exclusive jurisdiction. So it's quite difficult to say that, Dennis McShane's been referred, no doubt in reliance on the Court of Appeal, when the whole question is, did the Court of Appeal get it right? And so we do respectfully submit that my learned friend's condemnation of us as unrealistic because the balance of power happens to, at this present moment, given two judicial decisions and massive political pressure and public pressure, be in favour of acquiescence, that those are the realities. That doesn't overpower centuries of principle and the need to maintain the autonomy and independence of Parliament. My Lords, finally, I've already referred to the principle of equality, saying that really that there are disadvantages and advantages, and that really my learned friend can't pray in aid the principle enunciated by the minority in the Trinidadian case. But could I just make this further point in relation to equality and wider questions of fairness? Were there to be a trial, inevitably, and certainly were there to be a conviction and the question of sentence, inevitably the issue will arise. What about the other 300 MPs who repaid expenses which were said to be improperly obtained? What about the 140 people who were actually ordered to make repayments by the Legg report and made those repayments? And how can the judge deal with this without having regard to the approach taken in those other cases and the approach taken by Parliament in those other cases? And their adjudications, and as my Lord Brown put to my learned friend, in one of the cases, I think it's the Baroness Udden case, it said fraudulence. I think the sums are in excess of anything that are being the subject of these prosecutions. How can it be said that that's equality before the law, treating like cases alike and different cases differently? And how can you avoid raising questions or impeaching the adjudications of Parliament, or at least referring to them, criticising them, questioning them, in dealing fairly with these defendants? And so we respectfully submit, inevitably, they will not be being treated as equal before the law, or like cases being treated alike. And inevitably, this notion that there is some simple and fair dividing line between criminality for the ordinary courts and contempt for Parliament, it just breaks down. And we do respectfully submit that that demonstrates that if there is an exclusive jurisdiction, which we respectfully submit there is, that leads to swift, consistent and fair treatment. And to have this system whereby the election of the executive, some are singled out for exemplary punishment and others are left to the semi-exclusive jurisdiction of Parliament, is the very opposite of fairness and consistency in the rule of law. And so, my lords, if my learned friend struck any chords by his invocation of the principle of equality before the law, we actually say that the principles of equality before the law go all the other way, and it's important that there be consistency of treatment. Of course, we know there's a new order, as it were, being introduced from now on with the independent review panel, or payment panel. But in these cases, we submit that the existing fundamental principles of exclusive jurisdiction, and that these are covered by proceedings in Parliament, should apply.
The Court is grateful to counsel for their submissions and will reserve its judgment.